going to move along to copyright. Copyright, in essence, is the right to copy. It's the exclusive right for a creator to determine who may and who may not use, replicate, duplicate their artistic or literary works. What are some things that can be protected with a copyright? You have sound recordings. You have music lyrics, photographs, artwork, illustrations, blog posts, commercials, marketing and advertising materials. You have ebooks. Anything that is artistic and literary, and it meets these three requirements. It has to be original, it has to be an expression, and it has to be a fit to something that is tangible. So what does that mean? Ideas are not protected with a copyright. So if you meet with an investor and that meeting is not recorded, you didn't write your ideas down, and you're just having a communication with that investor, the words that you are speaking will not be protected under copyright law. The reason why is because it's not a fit to anything tangible, something that you can see, something that you can hear, something that you can touch. Another example of what is not protected with copyright, you have recipes. Mere listing out of ingredients is not sufficient to be covered under copyright law. Now, if you take that recipe and create a book, and you add photos and illustrations and additional content aside from just merely listing out ingredients, then at that point, you may be eligible for copyright protection. Facts. Facts are not protected with a copyright. Facts meaning your date of birth, telephone numbers, social security numbers, things that are common knowledge. There's no originality in that, and it fails the copyright requirements. Now, where do you file for copyright protection? You go through the United States Copyright Office. The process takes anywhere from 3 to 6 months, so long as there are no issues with your application. How long does a copyright last? It depends on the author. So let's just take an ebook for an example. And let's say that that ebook has one author. The copyright registration will last for the lifetime of that author plus an additional 70 years. Now let's take that same ebook and let's say that instead of one author, it's a total of 5. That copyright registration will last for the lifetime of all 5 authors plus an additional 70 years. Now let's take that same ebook example and let's say that the author was either anonymous or they used a pseudonym, meaning that they used a nickname, or that they did it as part of a work-for-hire arrangement. If that is the case, and it falls in one of those 3 scenarios, the copyright registration will last 95 years from the date it was published, meaning the date it was released to the general public, or 120 years from the date it was created, whichever occurs first. Okay? Now, before I move over to trademarks, I got to bust some myths that I've been seeing on these internet streets when it comes to copyright. And I see we are on. Okay, there we go. Thank you. So 3 myths that I'm going to bust real quick. If you hire someone to do something for your business and you do not have anything in writing, the law says by default, the person who created that work for your business is the owner of the thing that was created, even if you paid for it. So what is an example of this? Let's say hypothetically you pay someone $500 to do a logo for your business. You don't have anything in writing. By law and by default, the logo designer will have full rights to the logo that he created for your business, even though you paid $500 for it. Okay? Now, the thing about it is that some of these graphic designers, some of these photographers, videographers, they are hip to the game, right? And they prey on small business owners' ignorance to this law. So let me drop some gems for you real quick. Now, if you do not have anything in writing that gives you the full right to the thing that was created, some of these logo designers would say, pay me $500, I have all rights to what I created for you, but you can use it, meaning you get a license to use it for your business. But I still can use it for advertising purposes, and every time you post on Instagram, Facebook, you have to include my signature on whatever it is that I created. Or if you don't want to do that, pay me $750, right, for the same as that logo, and I will convey all of my rights and what was created to you. Real life scenario. How many of you all familiar with Brian McKnight? Love Brian McKnight, right? Now, those of you who are familiar with him, you know he got married a few years ago. And when he got married, he hired a videographer for the wedding. He didn't have anything in writing regarding who owns the rights to the video. So a few years later, he put out a music video. Matter of fact, this happened a few months ago. And the videographer filed a lawsuit against Brian McKnight because Brian McKnight included a 15-second clip of his wedding, his actual wedding, in his music video. It is likely that that videographer will prevail. So get it in writing. The best tool that you can utilize to make sure that you have full ownership over the things that are created on behalf of your business is to get a copyright transfer agreement. A copyright transfer agreement. This conveys all rights in the thing that was created to you. The second myth that I'm going to bust. A poor man's copyright. For those of you who don't know, a poor man's copyright is a way that folks could try to skirt around getting a copyright registration. They say that if you create something, the only thing you have to do is put it in an envelope, mail it to yourself, and that will establish the date it was created, and that will establish ownership. I'm here to tell you that that is not true. In fact, in 2019, the law changed. You cannot file a copyright infringement lawsuit against someone stealing your stuff until or unless you have a copyright registration in your hand. So don't fall for the poor man's copyright. In fact, it does not establish ownership. It does not establish the date that that work was created. It only established when it was placed in the mail. This last myth that I'm going to bust. I'm going to warn you, I'm going to step on somebody's toes in here with this one. That 8-word phrase that I've seen, you've seen, we all seen on social media. I don't own the right to this music. Don't raise your hand if you're guilty of this phrase, but let me break it down for you. That has zero legal effect. Putting I don't own the right to this music is like me and my sister who's in the back. We leave this convention center. We go to the hotel parking garage. We see one of you all with a rental car. We decide we need to go to the mall. We hotwire the car. Before we pull out of the parking space, I say, wait a minute, sis. And I pull out a piece of paper and a pen and I write, I don't own the rights to this car, and I put it in the windshield. If you were to call Little Rock Police Department, do you think they would hesitate to arrest us? No. It is the same philosophy. In fact, you put the world on notice that you are a thief. So the best way to get around this is if you are using music that you did not create in connection with the promotion of your products and services, get permission from the owner of the music, or 2, use royalty-free music.